commercially zoned, you might be subject to a site plan review, so there might be some level of review, yeah.
So,
growing and dispensing.
Council,
I'm sorry, sir, you
Mr.
can't speak, President.
Do you have any positive or negative to discuss relative to us considering a use permit for larger facilities?
Well, we are operating a little bit on the dark as to what the ultimate authority is going to be and what case law the courts are going to follow with respect to regulation of these facilities. I will say in the adult entertainment context, and this ordinance is tailored after our adult entertainment ordinance. Right. Because I litigated that case all the way to the Ninth Circuit, and the Ninth Circuit found that it did not violate the Constitution. And we don't have any cases really on the appellate level that deal specifically with the kind of ordinance we're contemplating here. But if the courts were to follow the same precedents that they follow in those kind of cases, conditional use permits are not allowed in those kind of First Amendment cases. The courts have said it's got to be a non-discretionary process.
So from the standpoint of a larger facility that's 5,000 square foot plus, which we hear is what it would be, if we were to place a conditional use permit on that, you think that would be in violation of where the courts have gone?
I don't know if I would go, I don't know if I would take my statement that far. I think I would say if the courts decide they're going to adopt the same reasoning or the same analysis to these types of restrictions as they do to adult entertainment, then yes, that would not be allowed. But whether they ultimately do that is an open question that we don't know yet. I mean, there's a difference between adult entertainment and marijuana because adult entertainment, of course, is federally protected under the First Amendment of the Constitution. Medical marijuana has a more narrow protection under state law.
Well, see, my issue would be, the overriding consideration would be traffic and health and safety over certain square footage. It should be considered with the advantages of having a use permit in the mix.
Well, here's what the courts say with respect to the First Amendment and why they would not allow those conditional use permits is because they would assume that that would give you an ability to use something like traffic or noise as a pretext to restricting the First Amendment protected rights. And so that's why they would not allow you to do a conditional use permit under those circumstances. Whether, again, those cases will be applied to this kind of restriction, we don't know.
In that case that you're referring to, or with the adult entertainment, was it a size restriction that you were seeking to get, or just was the issue an adult entertainment facility that was 1,000 feet that was going up to 10,000 feet, or was it some other issue?
It wasn't that issue because conditional use permits are not allowed in the adult entertainment context, and so we didn't even, and Tom Perrin drafted the ordinance, but I know this is true, he didn't even consider requiring such a thing.
So, Mr. Herron, can you weigh in on my little idea, or are we climbing up a tree that...
Mr. Murphy has some.
Well, I just want to echo council's concerns because, as you well know, the use permit process is a discretionary process, subject to CEQA, subject to public comment and input. I could see, given the controversy with these type of facilities, that the issues will not be necessarily focused on traffic or community character, but more about whether a marijuana dispensary should be or should not be allowed in a particular area. And so I could see that this kind of a debate or discussion would be focused on that argument as opposed to what I think you're trying to argue or what we're trying to focus on, which is the traffic implications, the community character implications, the noise issues, those type of things. It's not something I would recommend that we do with this particular ordinance.
Because we're never going to focus on the issues of a use permit. We're going to focus on whether or not it should be there, and by right it can be.
That would be my concern by having that requirement.
Mr. Chairman?
Okay.
Thank you very much, Mr. Chairman. I'd like to understand, Mr. Woods, what your concern is on size. Because if it's in an industrial zone, there wouldn't be the impacts for a residential zone. And
My issue is not to limit numbers so much as reasonable size for the unincorporated area. You know, many of our communities there's only a few that are, above 50,000. Most of them are 10, 15, 20,000 folks in a community, and to throw a 5,000 square foot dispensary in there is a pretty large concern. 1,000 square foot is reasonable. I mean, that services the area of 15,000 folks who have medical needs, and I'm a pharmacist. I totally agree with the use of medical marijuana for medical reasons. Very justified. I'm not saying anything negative about their use. I'm just talking about the impacts of larger facilities versus smaller ones in the unincorporated area.
Thank you.
You can't come forward unless one of the commissioners
Actually,
filed
I would invite you.
Okay, now you can come forward.
I can explain the difference here. Dispensaries that do not grow on site are usually small. All they have to do is take care of patients. Dispensaries that have to maintain their medication for those patients on site have to have more room.
So that's the primary
It's
difference.
as simple as that.
Okay.
Right.
Yeah. Thank you. Okay. Commissioner Reese, did you finish, Joe, with all the information that you wanted to?
Chairman Brooks, I believe I did. I mean, the only other thing is, there was this 1.5 million person, and that's, in the unincorporated county, we're closer to, like half a million. Yeah. That's it.
Thank you once again, Mr. Chairman. Back on the sign issues, is this ordinance subject to the sign ordinance, or would this use be subject to the county sign ordinance?
Yeah, through the chair, Commissioner Ballinger, it would be.
So there's no real reason to put an additional restriction as far as signage is concerned. Well, I think it's a complex issue, and I certainly appreciate the interests and the efforts on both sides of the issue before us today, but I'm prepared to make a motion to support staff's recommendation, if I can get a second from the commission, and move forward.
It's been moved by Commissioner Ballinger and second by Commissioner Wood that we accept staff's report